everyone please be seated? Good morning, everyone. I request all the dignitaries to please come forward for lighting of the lamps, and two student volunteers and teaching and non-teaching faculty for lighting. Thank you, everyone. A very good morning and warm welcome to respected Principal Madam, honorable guests, esteemed faculty members, and dear friends. I am Divjot Kaur Nanda from BLLB 4th year. I am very pleased to be here and much more delighted by everyone's presence at this special event. Today is the beginning of something very remarkable. We've gathered to commence lecture series Lex Scientia 2023 by Dr. D.Y.PATIL Law College in collaboration with Randive and Randive Associates. The very first topic of our first lecture is Women and Law, Recent Judicial Trends. Lex Scientia 2023 aims to advance the understanding among aspiring law students as well as people from among the legal field. Scientia means knowledge or expertness. In this lecture series, we would have the privilege to gain knowledge from experts of legal field who have gained command over it by having years of experience. Now let us proceed with the event. At first, I would like to call our Principal Madam, Dr. Ujjwala Shinde, to come and give welcome address to our respected guests and audience.
Very good morning. Respected dignitaries on the dais, Dr. S.E. AVHAD sir, Advocate Randive sir, advocates from various bars, PIMPRI bar, Shivaji Nagar bar, teaching and non-teaching staff of the college, and my dear student friends. I welcome you all to this inaugural ceremony of Lex Scientia, that is the knowledge of law. So, today we can say it is certainly a very special day, as in collaboration of Randive and Randive Associates, we are commencing a lecture series. The vision behind commencing such law series is very specific. Law cannot be studied in isolation. It is always read and interpreted contextually, considering the changing need of time. Deliberation of social, political, judicial perspectives of legal provisions are inevitable to understand the law critically. Study of versatile dimensions of law and its intersections in other disciplines is emphasized by National Education Policy 2022 also. Therefore, having a mission to provide the critical thought process amongst law students and advocates, this lecture series is initiated. For inaugural and for first lecture in the series, we could not imagine other than Dr. SUDHAKAR Award sir, because I always think that he is not only an advocate, but he is an elderly in the family, that we always go to him for consultation and guidance. We are truly grateful to Award sir, and as he is a teacher of a teacher, I always say, for accepting our invitation for the program. The theme of this lecture is certainly a topic in vogue. Recently we have celebrated Women's Day. On the other hand, United Nations Development Program in 2017 reported that women own less than 20% of the world's land. Now it's time to give them equal property rights. We are really fortunate to listen Dr. Awad sir, his views on women and law, recent judicial trend, with special reference to Section 6 of Hindu Succession. I would also like to thank our management, especially Dr. Somnath sir, for his wholehearted support for every activity of the Law College. I am thankful to all the participants that they are present here to listen the recent judicial trend. Thank you.
Thank you so much, ma'am, for a very warm welcome. For our very first lecture, we have a very accomplished resource person who is a senior advocate. Advocate Dr. SUDHAKAR AVHAD sir. AVHAD SUDHAKAR Eknath Rao, born on 10th of March 1953 in Chincholi in Ahmednagar district, Maharashtra. He has passed his SSC in 1970 from Dada Chaudhary Vidyalaya, Ahmednagar, with first class and secured first rank in school. He has passed his BSc examination in first class with distinction in 1974 from Modern College, Pune. He passed his LLB examination in 1977 from Pune University and secured first rank in second and third year LLB from Pune University, and passed his LLM examination in 1976, securing first rank. Sir has been awarded Tulpule Gold Medal and other prizes for outstanding performance at law examinations. He has been conferred with PhD in law for his thesis submitted to Savitribai Phule Pune University on the topic Global Dimensions of Human Rights and Evaluation of Fundamental Rights under the Indian Constitution. Sir has been teaching law since 1977. He has been coaching law students in all the subjects and conducting coaching classes for judicial services examination. There are few thousand advocates practicing throughout India, being his past students of his law classes. There are more than 250 judges in Maharashtra state, being students of his coaching classes for judicial services examination. He has been a practicing lawyer since 1977, having a standing of 45 years of experience and practiced on National Green Tribunal, civil, criminal, revenue, cooperative sides with specialization in land laws. He has participated in a number of conferences at state and national level, has submitted his papers at such conferences, and has been a member of Land Titling Committee by Government of Maharashtra, and delivered lectures at almost all district bar associations and some taluka bar associations in Maharashtra state. Has participated in continuous legal education program by Bar Council of Maharashtra and Goa at various places. Adding to his various achievements, he has written a couple of books for law students, such as Draftsman for Practitioners, Law of Notices for Practitioners, Judicial Services Examinations, Real Estate Development and Regulation Act 2016, Handbook for Law Entrance Exam CET. And he has a collection of poems called Kavya Suddha. Sir has also held the office of Chairman of Bar Council of Maharashtra and Goa from 2002 to 2003 and has been a member of Bar Council of Maharashtra and Goa from 1998 to 2003. He has worked as a legal advisor for Pune Municipal Corporation and many state and national level organizations. Sir, it is really an honor to have you here with us delivering this lecture. Thank you so much on behalf of Dr. D.Y.PATIL Law College and Randive Randive Associates. Let us have a huge round of applause for our honorable guest. Now, I request our respected Principal Madam, Dr. Ujjwala Shinde, to kindly felicitate our honorable guest, Dr. SUDHAKAR AVHAD, sir. Thank you so much, ma'am. Now, it is my privilege to speak about my very own college, Dr. D.Y.PATIL Law College, which has left no stone unturned to contribute for legal fraternity by organizing such events. Dr. D.Y.PATIL Law College, PIMPRI, was established in the year 2001 under the patronage of Honorable Chairman Dr. P.D. Patil, sir. The college is affiliated with Savitribai Phule Pune University and recognized by Government of Maharashtra and Bar Council of India under the auspices of Dr. D.Y.PATIL Unitech Society. The college is situated in PIMPRI suburb and is one of the premium colleges in the vicinity. Since 2001, college has achieved various milestones like successful organization of national level moot court competition 2019, establishment of Legal Aid Center in collaboration with District Legal Services Authority Pune in 2021, successfully organizing National Virtual Mediation Competition 2021. The college is accredited by ISO and college has received many awards like Swachhata Action Plan Institution, Certificate for Establishment of Innovation and Startup Cell, Center for Innovation, Incubation and Linkage, Savitribai Phule, Pune University 2021. Attending a 5-day full-time civil defense training workshop, SPPU, in March 2022, and many more. These versatile achievements of the college were certainly not possible without the right vision and apt guidance of a beloved and respected Dr. Ujjwala Shinde ma'am. For recognizing ma'am's valuable contribution in this field, Randive and Randive Associates wishes to felicitate madam. I request Anant Randive sir to kindly felicitate Ujjwala Shinde ma'am. Thank you so much, sir. Thank you so much, ma'am. So, this initiative of lecture series has been taken by our beloved Advocate Anant Randive, sir, who is the Managing Director of Randive and Randive Associates, which is a reputed, skilled, professionally managed law firm with years of experience. The main areas of the firm includes business law, corporate finance, capital markets, corporate litigation, financial services, banking, agriculture, litigation, arbitration, taxation, real estate, infrastructure, consumer protection, inheritance, matrimonial issues, criminal litigation, environmental protection, drafting of deeds and agreements, appellate work at high courts and supreme courts. With a team of highly qualified and experienced legal professionals, the firm stands out for its approach towards understanding the requirements of client and providing unique solutions with quick turnaround time. Randive and Randive Associates has a pan-Maharashtra presence with offices in Pune and Aurangabad. The firm represents the Pune Municipal Corporations, PIMPRI Municipal Corporation, Pune Metro and State of Maharashtra as the appropriate authority of PCP NDT cases also. The firm also provides legal advice on various topics whenever asked by the corporation. The firm is not only committed to providing legal services but also believes in creating great lawyers for future. As an effort to providing legal education through practical exposure, they welcome young and budding lawyers to have a real-time experience in this field and continuously provides internships to students from various law colleges in Pune and across India, like Dr. D.Y.PATIL Law College, Army Law College, ILS College, Navamal Firodia College, Shivaji Maratha Law College, MIT Law College, Marwadi University, and students from Rajkot, Gujarat, Jindal Law School, Missouri and Dehradun, MP Law College, Aurangabad, etc. On a regular basis, the firm also organizes and has been a jury at various moot court competitions. Randive and Randive Associates take pride in being the official sponsors for the annual National Moot Court Competition organized by Dr. D.Y.PATIL Law College. Since its inception, they have always believed in the highest level of integrity, followed a people-oriented approach, and given back to the society whenever possible. At Randive and Randive Associates, the principle of client first is followed for providing reliable and highly effective services. The spirit of continuous learning, strong tenacity, and continuous innovation is the backbone of Randive and Randive Associates. Let us have a huge round of applause for Advocate Anant Randive and his firm Randive and Randive Associates. I now request our respected Principal Madam to kindly felicitate Advocate Anant Randive, sir. Thank you so much, ma'am. Thank you so much, sir. Let us not wait anymore and begin with our session. I kindly request our honorable guest, Advocate Dr. Sudhakar AVHAD, sir, to kindly commence the lecture.
Honorable Principal, Dr. Shinde Madam, faculties and lecturers, D.Y.PATIL Law College, my esteemed colleague and Managing Director of Randive and Randive Associates, Advocate Professor Anant Randive, Advocate Rohan Randive, student friends, brothers and sisters. I'm very happy to be associated with you this morning. I've been called upon to participate the opening lecture of the series based on women and law. Especially, I have been assigned the task of exploring the subject based on Hindu Succession Act and the woman empowerment, or in short, rights of a female under Hindu law. Before I come to today's topic, I would like to say a few words about this firm, Randive and Randive Associates. We have taken this initiative in collaboration with or in joint venture with Dr. D.Y.PATIL Law College. Especially these Randive brothers, coming from a very remote and rural area in Maharashtra state. They have been established in Pune with all adversities, difficulties, problems, and they have been flourished into a rather national level firm in Pune, operating at Pune and at Aurangabad. These brothers, they practice from Taluka level to Supreme Court of India, and as such, they have been crowned with the prestige in this legal profession. I congratulate Randive and Randive Associates for having this collaboration with Dr. D.Y.PATIL Law College for the purpose of today's lecture series, that is Women and Law. You'll find, friends, such sometimes national level firms having standing of hundreds of years or couple of decades. They take such pride in commencing such lecture series. I really express my gratitude to this institute for allowing Randive and Randive Associate to associate with them. Here I find the blend of rural and urban areas together to deliver the goods to the customer of the goods, that is the law students. I also congratulate the principal, Dr. Ujjwala Shinde madam, for commencing such lecture series. Friends, I have been in this legal profession and this law teaching for last 46 years. I have seen in most of the law colleges, only theoretical subjects are taught. A law student, after becoming a lawyer, he is not knowing how to practice and what are the practical difficulties. And next, at least 5 years have been invested in learning how to practice. This institute, I am really happy that they have started such courses or such lecture series wherein students at the budding level, they have been enlightened as to how the practical aspects are also to be seen. They are teaching you or they are commencing such a lecture series in collaboration, not only teaching you the theoretical subject, but also taking you through the course of law and the plethora of the judgments by which law has been established and settled in India and especially in Maharashtra state. On this backdrop, friends, I will enter into the subject, that is women empowerment, women and law, and especially in the light of the Hindu Succession Act 1956. Friends, this goes long back, at least few thousands of years back in Indian soil. Especially, rather there is a journey from couple of thousand years, what we call to be ancient period, till 11th August 2020. There is a long span wherein rights of female, they have been discussed and decided and have been crystallized by the Supreme Court of India in a very recent judgment based on this topic. The judgment has been delivered by the Supreme Court on 11th August 2020. This journey of couple of thousands years will discuss in say 1.5 hours. I hope all of you will respond to this topic if I exceed a little beyond the given time. As per the schedule I was looking into, 1 hour's time has been given to me. 45 minutes time has been given to me. But friends, a lecturer may be satisfied with 45 minutes. But here is a lecturer plus advocate. So my time is going to extend certainly beyond 45 minutes. So you please bear with me. But today, when going home, you will find you know something which a lawyer of at least 10-15 years standing knows. So I will make you conversant with all these process and procedures of the courts, including the Supreme Court of India, and as to the woman empowerment. To understand this process of woman empowerment in India, let us go back, especially as to Hindu system, couple of centuries back, thousands of years back. Story starts with the Hindu system, ancient Hindu system. As per the ancient Hindu system, especially in respect of proprietary matters, you will find amongst Hindus, there were different categories. Especially, there were two categories of Hindus. There were two classes of Hindus. There were two schools of Hindus. And especially, this entire episode goes to at least 3,000 to 4,000 years before Christ. And this is with reference to the concept of the Vedas, Upanishads, and Puranas. Hindu law, it has been rooted in Vedas and has been fleshed in Upanishads. This Hindu law system, as to property, is based on two aspects. This entire Hindu law system, as to property, was based on a concept that especially amongst Hindus, based on Manusmriti, there were different works done by different jurists. I will not take into all details, but I will make you conversant as to the same. Why there were difficulties, why our better part, called as better part, and women were not given any right to property. Very religious authorities, very just authorities, they have blatantly refused right to property to our better aspect or to the woman, to the female. And for that purpose, this Manusmriti was further worked upon, and there were two schools of Hindus found. They were founded on these basic premises. Firstly, there was Mitakshara school and there was Dayabhaga school. Of these two schools of Mitakshara and Dayabhaga, I will take you only to the speciality of these two schools. One was patriarchal system, other was matriarchal system. You'll find today also in India, Hindus are divided into two factions, into two groups, into two schools of thought. First school of thought of Hindus that relates to matriarchal system, second relates to patriarchal system. Matriarchal means mother. So mother is the center of the family. Other is patriarchal, father is the center of the system. And accordingly, especially in Bengal province, today's Bengal province, that today includes Bengal, Orissa, and some part of Bihar. This is called as Bengal province then. In Bengal province, there is Dayabhaga school of Hindus. And Dayabhaga school of Hindus, it provides for matriarchal system. So mother is the center. All rights are vested in mother's hand. Even mother and female or the women are entitled to proprietary rights. This is a speciality of this Bengal school or Dayabhaga school. While rest of India, rest of the Hindus in India, they belong to patriarchal system. That is called as Mitakshara school. This Mitakshara school is a patriarchal system. Father is the center of the system. Male is the center of the system. Therefore, these two schools are diagonally opposite friends. In one system, male is the dominant factor, male is the center point. In other system, female or mother is the center point. And accordingly, our laws were divided into two factions in the beginning. Our main issue, especially in rest of India, excepting Bengal province, related to this Mitakshara school. We all in Pune, we all in Maharashtra, we belong to Mitakshara school. So, nicety of Mitakshara school was, female had no rights. No doubt, if we read the rich glories of the Hindu system, you'll find there were great such women, female, they were given respect, but no property. In our family, mother and grandmother, they were treated as goddesses, but without property. Because as per Mitakshara school, female had no rights into property. On one side, we respected them like goddess. On other side, they were without properties. They had no property rights. This was the concept in respect of Mitakshara school. However, in Dayabhaga, female were given equal right with reference to male. Daughter was given equal right with that of the son since thousands of years. So from thousands of years, we had two avenues amongst Hindus, patriarchal wherein only male were given rights and matriarchal wherein male and female were given equal rights. Based on these premises, we have to come to today's subject, especially in respect of Mitakshara school. In rest of India, excepting Bengal school, in Mitakshara, what happened? The female, they had only two rights. Very rich Hindu system, respectable Hindu system, it suffered a great setback. And that setback was, female were not treated equal at par with male, and they were given only limited aspects in property rights. First, maintenance. Right to maintenance only. To live only. Necessary to live only. And secondly, the right was given was called as Stri Dhana, her personal ornaments like Mangal Sutra and personal ornaments called as Stri Dhana. Only these rights were recognized. No rights into land, no rights into house was recognized as per this very rich heritage Hindu system. This rich heritage Hindu system denied all these rights to our Hindu female. On the other hand, the matriarchal system of Dayabhaga in Bengal, they recognized for thousands of years rights of female at par with male. Both were treated equally amongst Dayabhaga. On these premises, This system continued till Britishers came in India. Till British people came in India, the Hindu female, she had no proprietary right. She was respected in house, but when the property matter came, she was not given any right into property. Especially amongst Hindus, then the law was very simple as to property. Law was very simple as to family. Law is very simple in respect of co-parcenary. Friends, so as to understand right to property concept, let us first understand 4 simple key concepts of Hindu system. Every person, every law student must be conversant with these 4 key concepts. And these 4 key concepts, they are firstly Hindu family, Hindu joint family, Hindu co-parcenary, and ancestral property. Ancestral property is the center point around which entire Hindu property law rotates. This is the axis around which entire Hindu property law rotates. And to understand this, let us see what is Hindu joint family. Every now and then, we speak of Hindu joint family. What is Hindu joint family? And you will find there is a very wider notion of Hindu joint family. What is Hindu joint family is a family having common ancestor, descendants from common ancestors, plus wives of the male members, less married daughters who are joint in food, joint in worship. They are said to be the members of the joint family. 3 yardsticks are necessary, that they shall be having joint in food, joint in residence, and joint in worship. Then such members, they constitute Hindu joint family. Who are the members? Common ancestor. Then descendants from common ancestor. Then wives of the male members coming from other families. They constitute Hindu joint family. And daughters of this family, when they are given into marriage to other families, then they are to be deducted from this family. This is what is Hindu joint family. Then this Hindu joint family, as has been observed by jurist Mullah, Sir Dinshaw Mullah, in his book called as Principles of Hindu Law, he says that there is no need to have any property in Hindu joint family. To constitute Hindu joint family, we have not discussed that there should be the necessity of property. Hence, Mullah says that there can be a Hindu joint family of beggars also. There is no need of any property. Based on this, we go to the next concept. Next key concept is as to ancestral property. Every now and then, you take out any book on Hindu law, you take out any judgment on succession law, you'll find a key word called as ancestral property. No discussion is conclusion complete unless we refer to the concept of ancestral property. Let us, friend, therefore see in very simple language at elementary level of law student, I will tell you what is Hindu joint family. So a Hindu joint family is a very, very simple concept to understand. Hindu joint family in the hands of a person like me, a Hindu, is a property coming from father, father's father, or father's father's father. So property to me from my father, father's father, or father's father's father is ancestral in my hands for my son, son's son, or son's son's son. So there are 3 degrees or generations upwards, and there are 3 degrees or generations downwards. And myself, how many degrees? How many generations? 7. And hence, in Hindu system, this is also styled and called as 7 degrees of representation. So this is ancestral property. So whenever concept comes as to ancestral property, one thing is sure, property has come from ancestors. Therefore, ancestral property. Then this ancestral property and Hindu joint family, when taken together, constitute co-parcenary. What is called in Marathi as Purusha Mandal. So, this co-parcenary is a concept wherein there are 4 elements involved. Only male members within 4 degrees or 4 generations holding ancestral property. When there are male members only, they are within 4 degrees and holding ancestral property, then that Hindu joint family with ancestral property constitutes co-parcenary. So what is difference between Hindu joint family and co-parcenary? This is very essential, friends, as a law student, to know our further discussion in coming 1 hour's time. So, what is Hindu joint family? Any member, male or female, any generations, however, constitute the Hindu joint family. Property not necessary. For co-partnery only male members within 4 degrees or 4 generations. And what is the utmost important, essential, basic element to constitute co-partnery is there shall be ancestral property. If there is no ancestral property, then there is Hindu joint family, but no co-partnery. And hence, Jurist Mullah, Sir Dinshaw Mullah has observed that there can be no co-partnery of beggars. So, there can be Hindu joint family of beggars, property is not required. But there can be no co-partnery of beggars because to constitute co-partnery, property is essential. This is the basic distinction. On these premises, we have to proceed to today's female position. So, this position continued whenever in any Hindu joint family, there were male and female members who were the owners of the property. Say, for instance, there is a grandmother, there are children, there are sons and daughters. This is a family. Who are the owners of the property? Is grandmother owner? Is mother owner? Is sister owner? Is daughter owner? No. In past, this female, even though they were members of the Hindu joint family, were not owners of the property. Who were the owners? Only male members. That too within 4 generations. And there must be ancestral property, then there was a co-partnery. So this was the concept to understand. Now, based on this system, if whenever father died or any co-partner died, what happened to the property? What happens today if any Hindu dies? What happens to his property? Today, if any person dies, Hindu Succession Act applies, and then there are provisions contributed in Hindu Succession Act, especially Section 8, Section 9, Section 10, Section 11, Section 12, and Section 13. They therefore provide for a series of sections for succession. And today what happens? If a Hindu dies, then his mother gets a share, his widow gets the share, his daughter gets the share, his son gets the share today. Then what happened in past? If succession applies, all male and female, they get the shares on succession. What happened in past? There was no succession. Surprisingly, you will find, before 1956, amongst Hindus, there was no succession. Daughters were not given any share. Widow was not given any share. Mother or any female was not given any share. Who were given shares? Only male members. That was called as survivorship. Therefore, up to 1956, for so many centuries, so thousands of years, in India, all Hindus were regulated by very simple equation called as survivorship principle. What survivorship means, I will tell you. If there are, say, 4 members or 4 brothers, in past, before 1956, before 17th June 1956, if before 17 June 1956 there had been 4 family, there were 4 brothers and 1 brother died. What happened? His share devolved on remaining 3 brothers, called as survivorship principle. His share was not given, friends, to his widow, his mother or his daughter. They were not given any share. Today what happens? If today any person dies or this brother dies, his share devolves on whom? His share devolves on his widow, his mother, etc. In past, this was not done so. What was the principle known as? Survivorship. So, all of you are clear with the concept as to succession and survivorship. Principle of survivorship means, in past, amongst Hindus, if any Hindu he died, then his share, property share, devolve on other male members of the co-partnery only, not his widow and say his mother and his daughter. That is called as succession. If it is given to mother, daughter, etc., succession. If it is given only to male members of the co-partnery, survivorship. So, we come to the first deductions or inference that, what is the inference of this discussion? In past, before 1956, what was the consequence of death? A person died, survivorship was the principle applicable, and only male members they could get, and other female members were absolutely excluded from getting the property. This continued till British period. I will tell you, our female in past, our sisters in past, our mothers in past, they had no proprietary rights, even after death. What happened? Britishers were the first administrators who had attempted to do justice to Hindu female. These Britishers or the British administrators, they started reforms in India for Hindus, conferring rights on our sisters and female members. There had been various legislations in past. Of various legislations, as a law student, I will take you only to one legislation of 1937. In 1937, Britishers, they enacted the law called as Hindu Women's Right to Property Act of 1937. Britishers, they had done a magic. Really, in the year 1856, there was a law as to Hindu Widows Remarriage Act. Then there was Gains of Science Act. Then there was Hindu Inheritance Act. And then the real magic was done by the Britishers. Thank them. All our females shall thank Britishers, because Britishers were the people who started giving proprietary rights to our Hindu female. And the first major step was taken by Britishers in the year 1937. In the year 1937, the Hindu Women's Right to Property Act of 1937 was enacted. And the magic was done. Revolutionary change was made only by 13 sections. How exhaustive the law is, friends, is not material. How drastic provisions are incorporated is material, has been exhibited by only 13 sections of 1937 legislation. What happened in past? For thousands of years, no right to property to female. For the first time, during British period, in the year 1937, proprietary right was given to Hindu female. And this proprietary right was given, I will discuss with you in a couple of minutes with this reference of 37 law. Up to this time, if a Hindu co-partner died, then his widow was left without any property. She had to live at the mercy of the other male members in the family. Even though she was a widow of a very rich person, but she had no property right, she has to absolutely live at the mercy of other male members of the family. Position has been changed by Britishers first time. In the year 1937, this law of 1937 has been enacted, friends. And when this 1937 law has been enacted, what was done? For the first time, when a Hindu died, then after his death, his widow was given certain right. First time in the history of Hindu law. After thousands of years in the year 1937, Britishers, they enacted such a law and held and provided that after death of a Hindu male, his property shall go to his widow. First time. But it was not absolute giving the property. It was said limited or life interest was created in favor of such a Hindu female. What is life or limited interest? What is absolute interest? Absolute interest means when she gets the absolute ownership. However, absolute ownership was not given. Ownership in totality was not given. Only life or limited interest was given. Means, in short, when husband died, property came to the share of widow, and the widow enjoyed the property during her lifetime. She could enjoy. If it is agricultural land, she could take the usufruct or the income or the food grains or the crops. If it is a rented house, she could get the rent, but she could not sell. That is limited interest. Limited interest means she could enjoy, she could possess, she could get the fruits thereof, but she could not sell in past. That is limited interest. But at least something was given after a couple of thousands of years. From nothing to something was the journey up to 1937. That was the first such provision wherein for the first time limited interest or life interest was given to her. We, the male community, was very selfish. Hindu male community was very selfish, because what happened that right was given to her for her lifetime, enjoyment for her lifetime, but with a condition. What is the condition? That after her death, property will come back again to some male. Male property for a temporary period during her lifetime had been given to her, and after her death, it was coming back again to some male member in the family. That was the consequence in respect of 1937 legislation. But something was given. At least subsistence was given to her, and she was happy that during her lifetime at least she could enjoy the fruits of husband's property. This happened. Then in the year 1947, India became independent. In the year 1950, Constitution came into force. The principle of equality was enshrined in the Constitution. Dr. Ambedkar, very jealously, very religiously, he incorporated right to equality in the Constitution, whereby male and female, son and daughter were made equal. This all happened in Constitution. This all happened in the books, but not in the practice. Even such fundamental rights were given to us. They were theoretical fundamental rights. No practical fundamental right to Hindu female was given by the Constitution, because our personal law system did not allow Hindu female to be equal with the male, irrespective of the coming into force of the Constitution and the provisions as to equality in the Constitution. But equality provided, all shall be equal, like should be treated alike. Irrespective of all this, what should have been the consequence? If everybody is equal, son and daughter are equal, then the daughter would have been given equal share in the family property with the son. This was not done. Irrespective of the Constitution, irrespective of the right to equality, this was not done. And for this purpose, it was thought fit that there should have been law reforms. And accordingly, a Hindu Code Bill Committee was constituted under the leadership of Dr. B.N. Rao. This very Dr. B.N. Rao, who afterwards became the consultant to the Constituent Assembly, and subsequently he became the first judge of India in International Court of Justice. Under his leadership, this Hindu Code Bill Committee was constituted, and when Hindu Code Bill Committee was constituted, it was to draft the Hindu Code for all Indians. But unfortunately, on the point of rights of female, there was controversy. On right of female, there was a controversy, and Dr. Babasaheb Ambedkar, he was for absolute equality of male and female. Male and female should be treated equally amongst Hindus. However, late Jawaharlal Nehru, then our Prime Minister, he did not agree with this proposal. These two high leaders, high position leaders, high profile leaders, they differed in their opinions. Jawaharlal Nehru was saying, let us not treat them equally at this level. It is a newborn Republic of India. While Dr. Ambedkar was very insisting as to that male and female should be given equal rights. Son and daughter should be given equal rights. As of you know, Dr. Ambedkar resigned from the ministry. He was law minister then. He resigned. He said, okay, then I will leave this ministry. He left the central ministry at the behest of, for the cause of Hindu female. He resigned. And then accordingly, the parliament then constituted the functioning. When parliament started functioning, Hindu Code Bill never came into existence. And 4 laws were enacted. Which 4 laws were enacted? Hindu Marriage Act, 1955. Adoptions and Maintenance Act, Minority and Guardianship Act, and fourthly, the Hindu Succession Act of 1956. This law came into force on 17th June 1956. That is our today's subject. Why I told you this entire history, so as to make you understand why at all this subject is important in India, and how for centuries and centuries Hindu female were denied rights. For the first time, this law was enacted. Came into force on 17 June 1956. And when this law was enacted in the year 1956 and came into force on 17 June 1956, then this law did consist only of 30 sections. Of these 30 sections, what happened? Section 1 to 4 are definitions. Then section 5, 6, 7, 8, 9, 10, 11, 12, 13, they provide for succession. Section 14, 15, 16 provide for female position and female succession. Then sections 17 to Section 29 provide for general principles, and Section 30 provides for testamentary succession in respect of Hindu. Based on this, we'll come to the today's subject entry into the subject. Let us see then what happened by virtue of this act, how our sister, how our female, she got a right in property. And such a female was given a right in the property by virtue of succession and not by survivorship. What was required to be changed? If at all we wanted to give, if at all we wish to give and desire to confer on female rights to the property, what should have been abolished? Survivorship. Because survivorship was the gimmick, whereby rights were given only to male and not to female. And therefore, so as to do away with this evil, it was necessary that principle of survivorship shall be given up, and it should have been substituted by succession. And for the first time, this succession law came into force. And what happened by this succession law? By virtue of this succession law, now the heirs were defined, and accordingly, now son, daughter, mother, etc., they were made class 1 heirs. We know in the schedule to the Hindu Succession Act of 1956, there are 4 categories of the heirs: class 1, class 2, agnates and cognates, of which class 1 heirs are very material. And accordingly, in respect of class 1 heirs and their succession has been stated in section 6 of this law. Real woman empowerment or beginning of woman empowerment after independent, in independent India, after independence comes with section 6. This section 6 has been substituted in the year 2005. So there are 2 versions of section 6. Old section 6 and new or substituted section 6. Let us first see old section 6. Old section 6 provided when a male Hindu dies, after commencement of this act, having his share in the Mitakshara co-parsonary property, then his share shall devolve on the surviving co-parsoners by the principle of survivorship and not as per this act. Provided that if he is survived by any female of class 1 or any male heir claiming through such a female heir of class 1, then his interest shall devolve on his heirs as per this act and not by survivorship. This was old section 6. I will make it simple. This is little technical sections. This section comprises of 2 parts. First, this incorporates survivorship as well as succession. Because the system in existence for hundreds and hundreds of years cannot be undone in one stroke, because people, they must be used to the change, and change must be slow and gradual. For such a gradual and slow change, provision has been made in section 6 old. Section 6 old provided that first there is survivorship and then there is succession. There is mechanism provided. There is inbuilt mechanism provided in section 6 of survivorship principle as well as succession principle both. You'll find even after commencement of 1956 legislation, there is a place for survivorship. Till there was a place for survivorship, and survivorship and succession were the 2 aspects. They were conditioned. What was the condition? What are the general principles stated? When a male Hindu dies, after commencement of this act, having at the time of his death his interest in the Mitakshara co-parsonary, then his interest shall devolve as per the principle of survivorship and not as per this act. Even though this act was made applicable, from 17 June 1956, irrespective of that, to some extent, the 1,000-year-old law was continued in India. It was not by one stroke. It was not stated that from today, no survivorship. This is not stated. What was stated? Survivorship will continue till this proviso applies. Survivorship or 100 years old principle will apply unless the proviso applies. And when proviso will apply? When this today's Hindu Succession Act will apply, and there was a condition provided that whenever there are two classes of heirs present, which classes? Any female heir of class 1. Any female heir of class 1, and who are female heir of class 1? Mother, widow, daughter, daughter's daughter, etc. So, in the first instance, female heir of class 1. If she is present, what will happen? If a Hindu dies and he is survived by, say, daughter, or say mother, or say his widow, what will happen? 1,000-year-old law will not apply. 1,000-year-old law will not apply, and this today's law, which is made applicable and enforceable from 17 June 1956, will be applicable. So what was the condition for applicability? Only first instance, female class 1 heir. There should be daughter, there should be mother, or there should be widow, etc. If they are applicable, read this law. If they are not present, read Manusmriti, read Mitakshara law, read Puranas and read Vedas, and then you can read all past texts. And if somebody comes and says, daughter says, I am present, shut the books of Manusmriti. Don't read all books. Let us not read Upanishads. Let us read only 30 section Parliament's law. So it depends on what? Presence of which heir? Female heir of class 1. Or there is other category also stated. Or any male heir claiming through female heir. And there is one simple illustration to avoid the confusion. Say that there was a daughter, she was married, and daughter has died, and there is daughter's son alive. Grandfather or father dies. If daughter was there, what would have happened? This act would be applicable. Survivorship not applicable. Old law not applicable. But today daughter is not alive. But daughter's son is alive. Proviso says sufficient. Either there shall be a female class 1 heir, or there shall be a male claiming through female class 1 heirs. Then this act is applicable. Is concept clear? So this was the very simple aspect whereby this act was made applicable by the good offices of section 6 of Hindu Succession Act. This very Succession Act provided for a concept called as notional partition. Nowhere in the book the word notional partition has been used, but all judgments, all discussions, all lecturers, they use the word notional partition as a consequence of section 6. This section 6, when made applicable and when succession took place, that was said as to notional partition. And the concept of notional partition has been explained in this law itself, but not under the name and style of notional partition. It is said, and his interest in the Mitakshara property, shall be deemed to be his interest immediately before his death. So, if there is a large family, say that there are 10 male members, what will happen? Co-parcenary. And then one person dies after commencement of this act, having at the time of his death his interest in Mitakshara co-parcenary, what will happen? What is his share? His share shall be as if he died before his death, partition taken place. So, say for instance, he died on 1st. Then law will say on earlier day his interest is to be calculated. Let us take that interest and then let us have succession in respect of his interest. That is what section 6 says. Then you will find there are further sections in respect of male and female succession provision have been made. This entire historic law, any student of law, any lawyer, or even a person like me practicing for 46 years and has reached 70 years of age should have one theme of this law. To understand this law from right perspective and then to write answers as well as to teach the law even at early stage, you can have relook into this law. And to have relook into this law is to study section 4, section 6, section 8, section 19 and section 30 of this law. You'll find there is a very nice, beautiful combination of sections. While drafting of this law, the drafting committee of the Parliament of India has taken into consideration this golden thread of the sections. What is the golden thread of the sections? Any law student or any professor or anybody as a student or as a teacher of this law or as a lawyer, he should know this binding and the binding force between these few sections. Which sections? This is the heart of this entire law. What is the heart of this entire law? Section 4. Then section 6. Then section 8. Then section 14. And then section 19. And then section 30. Only you read these sections and you will be master of Hindu law. You can teach Hindu law to others if you understand theme interconnecting these sections. Let us see what is section 4. Very interesting section, friends. Usually we the lawyers do what? We start reading provisions. But we don't read the elementary sections. This very elementary section, section 4, that provides the relationship between 1,000-year-old law and the new law. This relationship is regulated by section 4. Previously, where the law was required to be found? Vedas, Shrutis and Smritis and Puranas and Upanishads. And today, where we find the law? Succession Act. So, question is today, whether we are required to read Vedas, Upanishads, Manusmriti, Puranas, etc., or whether only to read the Hindu Succession Act. And answer is not either way. It is not said that you shall not read the Vedas. It is not said that you shall not read Upanishads. Yes, till today they are relevant in few areas of practice. Which area? We'll discuss. So, section 4 is the elementary section which provides insight to you when our past law is relevant and when our present law is relevant. Of the two, which is to be applied today. And then section 4 has very interesting wording. Section 4 had two parts, friends. Section 4.1 and Section 4.2. Section 4.2 has been deleted by 2005 amendment. There is only now Section 4.1a and Section 4.1b. Section 4.1a provides that any text, any rule, or any interpretation of Hindu law, or any usage or any custom of Hindu law prevalent immediately before commencement of this act shall cease to exist, for which there is express provision is made in this act. Very simple. By only 2 lines, the Parliament of India has defined when to read the past law and when to read the present law. This is the connection. What is the connection? What is not to be read? What ceases to exist? What is not applicable today? 5 things. 5 things are not to be read today. Any text, any rule, or any interpretation of Hindu law, or any usage or any custom of Hindu law becomes irrelevant today when? For which express provision is made in this act. If there is an express provision made in this act, don't read the past. But if there is no express provision made in this act, then read the law in text. So today, nobody can say that law in Vedas is not relevant. Nobody can say Manusmriti is not relevant. Yes, today also Manusmriti is relevant. Today also law in Vedas is relevant. In which area? For which there is no provision made in this act. If act is silent, if act is specific, then this prevails over all. If act is not specific, act is silent, then read the past. This is simple equation with reference to section 4. So this is relationship between earlier Hindu law and today's Hindu law. But the parliamentarians, at the stake of all their wisdom, also incorporated subclause B. And subclause B provided that not only past Hindu law is relevant or not relevant based on this discussion, but other laws. Other laws means excepting Hindu law, if some other laws they are applicable to Hindus, then they shall not be applicable to Hindus if there is provision made in this law. They will continue in force but will not apply to Hindus because there is a provision specifically made to Hindus as per this law. So friends, there are 3 things now. Before we come to any concrete discussion, as a student of law and as an advocate or as a lecturer, you must know 3 things co-relationship. What is the threefold relationship? 1, past textual Hindu law, Vedas and Smritis and Upanishads and everything. Second, the present law, Hindu Succession Act. And thirdly, other laws, other than Hindu laws. So, today to Hindus, we are primarily regulated by which law? Hindu Succession Act, 30 sections. But if these 30 sections are silent, then old Hindu law or the other laws. If there is provision, don't read those two. If there is no provision, read both those two. This is the simple relationship to understand. Based on this now, we go to the further consequence. Section 6 provided for class 1 heirs and shares to class 1 heirs. But this was very deceptive. As soon as this act was passed and amalgamated, the Hindu female and daughters especially were very happy. Yes, we have got right. But this was very deceptive one. All the female were deceived at the end of the male community. The male community who were having dominance over properties for thousands and thousands of years. Now by constitutional force they were required to part with the property, but they were not ready to give everything at one stroke. They started giving in piecemeal, slowly. What was the first attempt by Britishers? Limited interest. Now from nothing and from zero to limited interest. From limited interest, now in the year 1956 to some interest. Zero interest, limited interest, and now by 56 legislation, some interest. Let us see what is this some interest. How our female, how our sisters were deceived at the instance of the brothers. How male community, they did not give everything at one stroke. Female were required to fight till 11th August 2020. This is the long battle between male and female over proprietary rights. Let us see what happened here. Say for instance, this Hindu Succession Act came into force and there was a Hindu female class 1 heirs. So let us take very simple case for your understanding. There is a father, there is a co-partnership of father and son, and there is a daughter in the co-partnership. Before 17 June 1956, what happened, friends? If father died, what could happen? There was son only. Son became absolute owner because principle of survivorship. In case of co-partnership, there was a principle of survivorship. Female was not given any share. What happened in the year 1937? Widow was given share, but here is a daughter. So she could not get anything. But by virtue of this, what happened that she was given a share? In what? Say for instance, father died. Did it mean that son and daughter got equal shares? Say for instance, father had say 10 acres of agricultural land. If father died after 10 acres of agricultural land, whether by virtue of this act, daughter got 5 acres and son got 5 acres? No. This was not the division. This law was deceptive equality. Because what happened? There was a co-partnership. Who are the members of the co-partnership? Father and son. So this son said to the sister, sister, look, let us first sit together. Father died, he had only 5 acres. I was a co-partner, I had 5 acres. So I will take 5 acres as co-partner. So at the time of the father's death, what was his share? Only 5 acres. That will share equally. So in 5 acres, half was given to daughter, that is 2.5 acres. 2.5 acre was given to son as sharer. And 5 acres was given by him, taken by him as co-partner. So he got 5 acres as co-partner and 2.5 acres as heir, and he got 7.5 acres. She was given only 2.5 acres. This was the equality. This was the succession taking place by virtue of 17th June 1956. And therefore, there was no perfect equality even after independence, even after promulgation of the Constitution, not only that, even after 25 years thereof. And therefore, there was the demand from the Hindu female community. Education inculcated therein, education imbibed in their minds that we shall be equal in proprietary rights also. And they started claiming equal proprietary rights. And when they started equal proprietary rights, the first state in India to do it was state of Kerala. State of Kerala, in the year 1973, provided for this act, which came into force from 1975, the Kerala Hindu Joint Family Abolition Act 1975. In one stroke, what Dr. Ambedkar wanted then was done by Kerala state. For the first time in the year 1975. And in Kerala, you'll find from 1975, there is no co-parsonary, there is no Hindu joint family as such, there is only Hindu family. Means in state of Kerala, this concept of ancestral property has been absolutely done away with. By birth, there is no interest in Kerala now. The holder's death will decide the shares equally. And therefore, perfect equality has been brought in the most literate state in India, that is state of Kerala, since 1975. But as this was going on, friends, I think that I'm not boring you. It is not hyper-technical. I'm trying to simplify and bringing it to student level. So friends, bear with me for some more time and hope you'll be enlightened for that. So when this act came into force, and state of Kerala was the first state wherein they abolished the Hindu joint family. Then other state also started learning from state of Kerala. In the year 1987, state of Andhra Pradesh. In the year 1990, Tamil Nadu. In the year 1994, Karnataka. And on 22nd June 1994, Maharashtra state. They also provided for state amendments, wherein they attempted to do justice to female, bringing male and female on equal footing, daughter and son on equal footing. This amendment in Maharashtra state, in a lighter vein, is also said to be Mr. Sharad Pawar amendment. Fortunately then, Mr. Sharad Pawar, he was the Chief Minister of Maharashtra state, and it is said by of a joke that he had only a daughter, so he was favoring such legislation in favor of daughters. But nevertheless, he has done really justice to female in Maharashtra state, applicable from 22nd June 1994. Let us see what was this 1994 law. In one sentence, this 1994 law provided, since then, I will not take you to the sentences and the sections and the technicalities. Conclusion was that son is equal to daughter. For the first time in Maharashtra, it was said son is equal to daughter, and daughter was made a co-parsoner. As daughter was made a co-parsoner means she was given status of a co-parsoner, including proprietary rights. Means in father's property, what happened? If father died, son is equal to daughter. So son is equal to daughter means what? 1/2, 1/2. Earlier, son is equal to daughter meant 1/4, 3/4, because she was given 2.5 acres. Brother was given 7.5 acres. So she was given 1/4 and he was given 3/4. Now, real 1/2 and 1/2. Real 1/2 and 1/2 means if father died, then 5 acres will be given to daughter and 5 acres will be given to son, was the law in Maharashtra state from 22nd June 1994. Female were again happy. Earlier was Rishi and Muni, they given, Vedas they have given 0. The Britishers, they have given at least life interest. This 1956 legislation has given at least 1/4, 3/4 formula. For the first time in Maharashtra, it was 50-50. It was equal status was conferred on the female by virtue of this 22nd June 1994 legislation applicable in Maharashtra state. But friend, inadvertently, a mistake was left. And it was said that those daughters who are unmarried on 22nd June 1994 were treated like son. In doing so, in doing such justice, some injustice was caused. Which daughters were treated as son? Unmarried on 22nd June. And who were married then? Who were married? 1/4, 3/4. Married 1/2, 1/2. So this discrimination in the over-enthusiasm, so as to do away with the discrimination between son and daughter, discrimination was created between daughter and daughter. Are you getting me correctly? See, earlier was a discrimination between son and daughter. because earlier daughter was not given share. By virtue of 56 legislation, she was given 1/4 and he was given 3/4. So there was discrimination. Now in Maharashtra, it was desired to do away with this discrimination. Daughter should be given 50, he should be given 50. Both shall be given equally. In this over enthusiasm, a mistake remained. Which daughter? Only who was unmarried on 22nd June. And married then? 1/4, 3/4. Here, 1/2, 1/2. This was the rather lacuna left in this law. I will give a very simple illustration before we proceed to next part of the case law discussion. What happened? Very simple but consequential part was, say for instance, there was a father and he had say one son and 2 daughters. And in Maharashtra state especially we know, there is a marriage season during May and June, which is called in Marathi as Vaishak. So during this month there is a marriage season. These 2 daughters, one daughter was married on say 19th or 20th June. And other daughter was married on 25th June. What happened? Say for instance, these were the twins. Of the twin daughter, one was married 2 days before the amendment, and one was married after 2 days of the amendment. What happened? The daughter, if father dies, the daughter who married before the amendment, she could get what formula? 1/4, 3/4. And daughter married after amendment, she would get 1/2, 1/2. This was the discrimination left. You are getting me correctly? So in the beginning, nothing. Then by 37, life interest. Then by 56, 17 June 1956 legislation, 1/4, 3/4 formula. And then by virtue of this 1994 Maharashtra legislation, 1/2, 1/2 sometimes and 1/4, 3/4 sometimes was the consequence. This injustice was being faced and faced. This was realized. But you will find law moves at a very slow pace. This happened after 56. There was demand for absolute equality. As there was growing education, the female section started demanding absolute equality. Why not equal? Why not this marriage to be done away with? And therefore, accordingly, you will find in the year 2005, there was the Law Commission's report. Law Commission of India had a meeting in ILS Law College, Pune, in association with one NGO from Goa, and they had lengthy discussion and discourse on this topic at ILS College, Pune. Most of the dignitaries and lecturers and professors were called upon to participate in the discussion. And as a consequence of the discussion, a law was desired to be framed to do absolute equality. And absolute equality was struck, balance was struck by passing of the new legislation or amending the existing law. Law was to be amended, and the Law Commission, after its entire discussion, submitted a report to the Parliament of India called as 174th Report of Law Commission submitted to the Parliament of India. Report was submitted to the Parliament of India, and along with the report, there was proposed amendment draft was also annexed. When this Law Commission's report was submitted to the Parliament of India, along with the draft report that was received by the Parliament, Parliament considered it, and then Parliament thought it fit. Yes, this would have been done in the year 1956 itself. We're at fault. This would have been done by us when? Immediately after independence, about 50 years have been lost. And then in the year 2005, the Parliament of India passed an act. The Hindu Succession, into bracket amendment, bracket complete act, comma 2005. Accordingly, 2005 amendment has been enacted and passed by the Parliament of India, which came into force from 9/9/2005. And therefore, by this amendment, absolute justice has been made. So let us see the stages. First, 0. Then 37, absolute limited interest. Then 17 June 1956, some interest, 1434 formula. 1994, 22nd June 1994, unmarried daughters, 100%. And married daughters, lesser interest. And absolute interest has been given, and final stage of equality has been reached by virtue of the Constitution of India, whereby son is equal to daughter, absolutely no qualifications, marriage, etc., nothing. And son is equal to daughter was the formula made by this amendment. Let us come to today's amendment. Let us see that amended law which came into force from 992-2005. This law which came into force from 992-2005 provided for this amendment. This amendment is said to be consisting of this section 6.1, section 6.2, section 6.3, section 6.4 and section 6.5, only 5 subsections are provided in amended section 6. Friend, usually what happens, whenever amendment is made in the section or any part of the law, some words are taken here and there. This is called amendment. Something is added, something is taken away. But when entire section is taken away, and that is substituted by another section, new section. So this is not a word change or sentence change or paragraph change. Entire section is taken away and that is substituted by a new section. This is called as substituted amendment. So there is difference between amendment and substituted amendment. When some portion is changed, amendment. When entire law has been changed, substituted amendment. And there is an interpretation of statute provided here. What is interpretation of statute? The people who have learnt the subject of interpretation of statute, they must be knowing. There is different rules of interpretation for ordinary amendments. Usually, ordinary amendments, they apply from the date of the amendment unless they are made retrospectively applicable. However, whenever there is a substituted amendment, that shall be deemed to be in force from the date of the original act. Try to understand, friends. I will make you understand again. Amendment is made on what date? 9/9/2005. This is a substituted form of amendment. Even though this came into this act, this has been incorporated and brought into this act from 9/9/2005. What is the deeming consequence? What is the fiction of law? That this amendment, which has been done in this act today, shall be deemed to be in force from 17th June 1956. Are you getting correctly? Even though this is brought into today, for the legal purposes, that shall be deemed to be in force from that day. This is the consequence. So, by all means, the law was made, daughter was given share. After centuries and centuries fight of the two sexes, it resulted into success. They were given absolute share. They were given equal status. Daughter was made a co-partner. What is said? I will read only relevant provision of this section. Very tricky section. Very tricky section. And rather defective also. How sometimes it is said that the people sitting in air-conditioned offices make the laws for the people tilling in their lands in the noon. So lawmakers are sitting in air-conditioned offices. Law is made for whom? The laborers working in the field under the sun. These two conditions of their needs and the mind setup of the lawmakers is different, and therefore there is a defective legislation. This is the defective legislation. How this defective legislation was made, I will conclude within the next couple of minutes now. When this law was made, females were absolutely happy. Our daughters were absolutely happy. At least after centuries and centuries, we got justice and we got equal share. Previously, who had not given to them? Religion, Manusmriti, Vedas, Upanishads, they had done injustice to daughters. Then, to some extent, justice was done by law by the Britishers. Then, to some extent, justice was done by the Indian Parliament. Now, in respect of this, justice was denied to them by courts. Courts are there to do the justice to the female, but by virtue of next 15 years battle which we'll discuss, the rights which are conferred, denied rights were conferred on them, they were not given in a right spirit to the female, and this discredit goes to the courts. Courts, they have denied rights to them for next 15 years. First, they fought against religion. Then there was a fight between brother and sister. There was a fight between male and female. Now, this fight was over. Law said that Parliament said, now we will not come in between. Both of you are equal. But whether you are really equal or not, courts took 15 long years to decide. 15 long years to decide. What to decide? Whether really male is equal to female, and whether what Parliament has said that son is equal to daughter, what is the extent and truth thereof. This truth has been discovered by the court after 15 years long battle. I will take you through this battle. Shall I continue? What is your tolerance for next 15-20 minutes or not? May I continue for next 15-20 minutes? So friends, new section 6 provides for this bothering you for some time more. I'll be compensating you. I'll be giving a small note to you also. And a note about of 60-70 pages will be given to you for your ready reference. So at least for that, you bear with me for next half an hour's time. So friends, we come to this legal battle now. So Parliament, the books were denied, Parliament's law was set aside, and now matter went to the High Court. For the first time in India, interpretation of this new Section 6 came into force. What was new Section 6? How that was badly worded, how that was wrongly worded, and it has been said. New Section 6 says, on and from the commencement of the Hindu Succession Act, the interest of Mitakshara shall devolve as per this law, and A, B, and C, 3 clauses. It is firstly said that daughter is made a co-partner, and she shall have such rights and shall have all the liabilities. The words are very interesting, on and from. When from she is made a co-partner, when she shall have rights, on and from. On and from means what? On means what and from means what? We'll discuss on and from. And the simple word on and from required High Courts and Supreme Court 15 years to decide. High Court and Supreme Court, they took 15 long years only to decide what on and what from means. And let us see a short history of this litigation so as to make you understand how our female empowerment, my today's subject is female empowerment, how this female empowerment took such a lengthy time, such a long time to fight sometimes against male, fight against religion, and to fight against courts sometimes. And this long battle started from first time in Karnataka High Court. First issue forever arose after commencement of this act in Karnataka High Court, and was the case of Pushpalata versus Padma. In case of Pushpalata versus Padma, issue was whether this act is prospective or retrospective. Whether this act and such a status is conferred on Hindu female from 992005, or whether a daughter born before that, she could be benefited thereby or not. And the Karnataka High Court held that this act is retrospective. So this act is applicable to daughters born before 992005 also. This is retrospective consequence. Then, immediately within 1 year's time, there was a case before same High Court, that is Karnataka High Court, was the case of Prakash versus Phulavati. And again issue was whether this is prospective law or whether it is a retrospective law. And the Karnataka High Court said, yes, this is retrospective law. Benefit of this law shall be given to daughters born before 992005 also. So this was okay for Karnataka state. Immediately in Maharashtra, a case arose in Bombay High Court, and this case was the case of SUDHAKAR versus Chandrakant Desle, decided by Bombay High Court in the year 2010. Justice Roshan Dalvi Madam was the judge who decided this case. Issue was again before Bombay High Court. Whether this act is prospective or retrospective. Friends, those who are not understanding properly, I will explain in one sentence. Laws are having two fold of application. Prospective means law came into force on 9/9/2005. So this law will apply hereafter. Daughters born after this. Retrospective means that this law, which has been enacted and came into force from 9/9/2005, will act for daughters born before that also, was the controversy. Before daughters and after daughters who are covered is the controversy. In this case of SUDHAKAR versus Chandrakant Desle, Bombay High Court held no, this act is prospective only. Are you getting correctly? So from here, from Pune, we go up to Kolhapur, towards Bangalore, towards Karnataka. Up to Kolhapur, what was the law? Prospective. Only daughters born after 9/9/2005 will get law. As soon as we crossed the border at Kolhapur and entered into the border of the Karnataka, what was the law? This is retrospective. What was the consequence with reference to this law? If in this state, prospective. In that state, retrospective. And therefore, there was no certainty as to law. And as this happened, came the case before Bombay High Court. Vaishali Ganorkar versus Satish Ganorkar. And in this case, the issue again was whether it is prospective or retrospective. The Bombay High Court then, presided over by the then Chief Justice of Bombay High Court, Justice Mohit Shah sir, he, along with his companion judge, held, yes, this act is prospective only, not retrospective. So, two cases of Karnataka High Court, retrospective. Two cases of Bombay High Court, only prospective. Again, this decision of Vaishali Ganorkar versus Satish Ganorkar, a case had been to the Supreme Court of India. Vaishali Ganorkar versus Satish Ganorkar, Supreme Court. And when matter went to the Supreme Court said, dismissed, full stop. Law point is kept open, full stop. Let us see the consequence. In India, only court can write dismissed. One word only is Supreme Court. If High Court says dismissed, then there is ear pulling by the Supreme Court. If our trial court says dismissed, will not do. Because it is expected that whenever you pass any order, it shall be speaking order. Speaking order means you should give reasons for your orders. Only dismissal will not do. And in one of the case of the Bombay High Court, when Bombay High Court made a decision and only said dismissed, then there was a criticism by the Supreme Court. There were strictures from the Supreme Court against Bombay High Court. No, you shall not pass such orders. There shall be reasons given for your orders. But for Supreme Court, there are no bounds. This rule is not applicable to Supreme Court. In this case, Supreme Court said dismissed. No reasons were given. Not only this, Supreme Court said law point is kept open. So friends, why we go to Supreme Court? Why the people, they go to Supreme Court? Because law points are not certain in the trial courts. We want that law point should be decided by the Honorable Apex and Supreme Court. Therefore, people approach the Supreme Court and very contrary view was taken to by the Supreme Court. Law point is kept open. Law point is kept open means if a client comes to you as a lawyer, you will say, don't worry, there is a chance for you. Supreme Court has said, law point is open. It can be retrospective, it can be prospective. Don't worry, let us wait. So it resulted into increase of the litigation. Meaningful litigation, it did increase because of this decision of the Supreme Court in case of Vaishali Ganorkar versus Satish Ganorkar. As this was done, there was a case before the Supreme Court, there was a case before Bombay High Court. And as this was done, the case was before Bombay High Court again, and that case was from our town near Pune, Saswar. Ashok Gangadhar Sedge versus Ramesh Gangadhar Sedge. And Justice R.G. Ketkar, the retired judge of the Bombay High Court, now decided this case. And this case, friends, is a turning point in this entire law. This entire law in India is changed because of this judgment of Justice R.G. Ketkar of the Bombay High Court in the case of Ashok Gangadhar Sedge versus Ramesh Gangadhar Sedge. And in this case, Justice Ketkar, he said, I don't agree with the judgment of the Chief Justice of the Bombay High Court in case of Vaishali Ganorkar. He blatantly said, I don't agree with you. Whenever a judge says, I don't agree with two judges of the Bombay High Court, there is a provision in Constitution that is said to be reference to the larger bench, reference to the full bench. This was a decision of the two judges bench. He requested that reference should be made to the three judges bench of the Supreme Court. Accordingly, reference was made to three judges bench of the Supreme Court. In the case of Badri Narayan Shankarlal Bhandari versus Om Prakash Shankarlal Bhandari, decided by the Bombay High Court in the year 2014. This case was naturally to be referred to three judges. Earlier case was decided by two judges. And then this case was decided by three judges. Justice Mohit Shah sir, he was still Chief Justice of the Bombay High Court. And then he said, now let us have three judges bench. He said, I will also be present in the bench. So Justice Mohit Shah sir, the Chief Justice of the Bombay High Court, he presided over the bench, and there were two competent judges sitting with him. And then they had a re-look into their own previous judgment of Vaishali Ganorkar versus Satish Ganorkar. And then the Honorable Chief Justice of the Bombay High Court, he said, yes, we committed error in our earlier judgment. Vaishali Ganorkar is not correctly decided by us. And then he corrected himself by delivering a very nice judgment in case of Badri Narayan Shankarlal Bhandari versus Om Prakash Shankarlal Bhandari. And he said, yes, this act is not only prospective, but this act is also retrospective. This act is applicable to daughters born after 992-005, but this act is equally applicable to daughters born before 992-005 till 17 June 56 or before that. See the beauty. Daughters are of three categories. Daughters born before 56 legislation means daughters born before 17 June 1956. Daughters born after 17 June 1956 to 992-005 and daughters born after 992-005. Now, the Bombay High Court and Justice Mohit Shah sir, they have taken such a wider perspective and decision. They said that this act is applicable to all the three categories. Means, daughters born after 992-005, daughters born after 17 June 1956, and even daughters born before 1956. All means all daughters in short. Every daughter is included for application of this new law is the decision given in this case. By this time, the ball is rolling between Bombay High Court and Karnataka High Court. Till then, there was no concrete decision coming up in the Supreme Court of India. And that case, which was decided in the year 2010 by Karnataka High Court, was the case of Prakash versus Phulavati. That had been in appeal to the Supreme Court. And as we know, in Supreme Court, normally there is 10 years pendency. This case also took about 8-9 years in the Supreme Court. While this Karnataka High Court and Bombay High Court consequence was coming up, matter had been to the Supreme Court in Prakash versus Phulavati. In Prakash versus Phulavati now, issue was whether this act is prospective or retrospective. Whether this three judges bench decision of the Bombay High Court is correct, whether Karnataka High Court is correct, or whether Bombay High Court is correct. And in case of Prakash versus Phulavati, Honorable Supreme Court said that this act is prospective only, not retrospective. What said? This act is prospective only, not retrospective. And those two judges of the Supreme Court, they observed 3-point formula. This entire aspect has been done away with, and only 3 lines have been stated succinctly, very in a nice manner. They said, living daughters of living fathers, as on 992-005. This entire judgment of hundreds of pages can be reduced to one sentence. What one sentence formula? In Prakash versus Phulavati, living daughters of living fathers. So what is necessary on 992-005? Property must be available, father must be alive, and daughter must be alive. Of the 3 things, if property is not available, if father is died before that, or daughter has died before that, then this act has no application. So for application, 3 basic conditions are necessary, and 3 basic conditions are property available, father alive, and daughter alive. Was the simple equation by them. Within 3 months' time from this decision of this case of Prakash versus Phulavati, there was another case before the Supreme Court. And when this another case came before the Supreme Court was the case of Danama versus Amar. In case of Danama versus Amar, similar issue arose before the Supreme Court, but there was a little difference in facts. Father died before 2005. Father died before 2005, and daughter filed a suit against her brother for shares. Which share? Before 2005, which share was there? 1/4, 3/4. So as per the old formula, she filed a suit, and that suit was pending on 9/9/2005. Issue was before the Supreme Court. If father was not alive on 9/9/2005, whether that is sufficient or not. And Supreme Court said yes. Even though it has been said that living daughters of living fathers, irrespective of that, if there is a suit pending on 9/9/2005, father is not alive, but suit is pending, then daughter is alive, property is available, this is sufficient, and therefore act is applicable. Within 3 months' time came the next case in the Supreme Court, and that was case of Mangamal versus T.B. Raju. And in case of Mangamal versus T.B. Raju, again question was whether Danama is correct or Prakash is correct. Are you getting me correctly? I will restate in short. What was held in Prakash versus Phulavati? What is required for application of this new law? Father must be there, property must be there, and daughter must be there. On what date? 9/9/2005. What Danama said? Property must be there, daughter must be there. If father is not there, if suit is there, sufficient. So this was the difference. These two judges versus these two judges. Or rather we can say not versus, but there were inconsistent judgments or views expressed by the judges. One said father must be alive, other says father need not be alive. On these premises was the case before the Supreme Court in the case of Mangamal versus T.B. Raju, whether of these two cases which is correct application. And then again it is said that Danama is not correctly decided, but Prakash is correctly decided. So two judges, and two judges. Based on this, there was a controversy. You will find, friends, to practice in the trial court was very difficult. And that too, the work of the trial judges was extremely difficult because they cannot disobey the judgments of the Supreme Court. And we the lawyers were pulling and filing before the trial courts, this judgment and this judgment and this judgment, inconsistent judgment. Can trial judge say, I cannot follow Danama? Can trial court say, I cannot follow Prakash versus Phulavati? Supreme Court judges can say, I don't agree with my brother judge, but trial judge cannot say. Was the difficulty in the trial courts, and there were thousands and thousands cases piling up in the Union of India. All our courts were flooded with partition matters. They were flooded with such daughters and brothers disputes. And this started from which case? Vaishali Ganorkar, because law point was kept open. And then there were such controversial or inconsistent judgments of the Supreme Court coming up. And by this time, case came from Delhi High Court. On the background of all this inconsistency, on the background of all this judicial uncertainty, case came from Delhi High Court. And there was a case of Vinita Sharma versus Rakesh Sharma decided by Delhi High Court. And then, while deciding that case, judgment was delivered, and against that judgment, now appeal has been preferred to the Supreme Court of India. From Bombay High Court and for Karnataka High Court, friends, it is very difficult. We have to travel 1,000 kilometers to Delhi. But in Delhi, it is very simple. Some of you must have gone to your Supreme Court trip. You must have seen that in the square, on one side there is Delhi High Court, and other side there is Supreme Court. So only to cross the square and come to the Supreme Court. As soon as this case was decided by Delhi High Court, appeal was preferred to the Supreme Court of India. And then Chief Justice was required to frame and form a larger bench of 3 judges. Because 2 judges, Prakash versus Phulavati. 3 things. 2 judges, Danama versus Amar, only 2 things. And third, Mangamal saying that this is wrongly decided, this is correctly decided. And therefore now, for the first time on this issue, as to daughter's right, 3 judges bench was constituted by the Supreme Court of India in the case of Vinita Sharma versus Rakesh Sharma. And issue was whether this act is prospective, retrospective, or retroactive. And accordingly, the Supreme Court said that this act is retrospective to some extent, prospective to some extent, and retroactive to some extent. This act is all the three way. And it is said further in this decision that this act is applicable if property is available that is not disposed of before the commencement of this act. And secondly, daughter is alive. Father's presence is not necessary. So it has been held that Prakash versus Phulvati is wrongly decided and is expressly overruled. Case of Prakash versus Phulvati is overruled by the Supreme Court. Prakash versus Mangamal's cases has been overruled, and case of Danama has been partly overruled to the extent of inconsistency, and the Supreme Court came out with 2-point formula only. What? Property should be available. And secondly, daughter should be alive. If father is dead and gone, then irrelevant. Not look into that issue. Was the ultimate decision delivered by the Supreme Court on 11th August 2020 in the case of Vinita Sharma versus Rakesh Sharma. By the time this judgment has been arrived at, very strange issue arose whether this law is applicable in state of Maharashtra as it is, or whether law is different in Gujarat or Madhya Pradesh state and in Maharashtra state. See friends, Article 141 read with Article 142 of the Constitution of India. Law laid down by the Supreme Court shall be binding all courts in India. Law of the Supreme Court is binding on all courts, and that is available in all states equally. Whether the judgment of Vinita Sharma decided on 11th August 2020 is applicable equally in Maharashtra and Gujarat, or Maharashtra and Madhya Pradesh, or not. And this controversy has been stated and explained. A very recent judgment has been delivered by Justice Kankanwadi Madam of Bombay High Court at Aurangabad. And this case has been explained, and the consequences have been explained by her, by leadership in detail. And has been held that this law expressed by 3 judges bench of the Supreme Court in the case of Vinita Sharma versus Rakesh Sharma is not as it is applicable in Maharashtra state, as it is not applicable in Karnataka state, as it is not applicable in Andhra Pradesh High Court, Andhra Pradesh state and Tamil Nadu state. Why? Because in these 4 states there was state amendment. In Andhra Pradesh 87, in Tamil Nadu 90, in Karnataka 1994, and in Maharashtra 22nd June 1994 there were state amendments. So say for instance, say in Maharashtra state, this law came into force from what date? 9/9/2005 or 22nd June? 22nd June. The law was already in force from 22nd June. This law was in force. And say for instance, any daughter, she was unmarried on 22nd June 1994. What happened? She became co-partner. Daughter is equal to son. And say for instance, she died in the year 2000. She died in the year 2000. She died as what? As a daughter or as a co-partner? If she died as a co-partner and is survived by her son and daughter, is it necessary in the year 2005 that she shall be alive? And friend, this is the modification, and therefore you shall read in between the lines. So this judgment is not applicable in state of Maharashtra as it is, or in those 4 states wherein there was a state amendment, this judgment is not applicable as it is. So first state law will apply and then central law will apply. This is the consequence in respect of this. What is today's law? Today's law is the case of Vinita Sharma versus Rakesh Sharma. This court, while deciding this case, has held very nicely. Judges are human beings. They are also carried by emotions. And it has been held by them that there was a decision given by the Supreme Court of India in the year 1992 in case of Savita Samvedi versus Union of India, wherein Supreme Court had observed that son is a son till he marries. Yes, and daughter is a daughter for life. So, the judges who decided this case, they could not refrain themselves from reiterating that principle laid down by the Supreme Court in Savita Samvedi's case, and has held in this case that son is a son till he marries or brings a wife, but daughter is daughter for life. Then why not to give equal share to her was the consequence. And accordingly, full status has been conferred. Friends, in this entire process, you'll say, why it took long 15 years to decide? We are now on the last point. Those who are tired, for them there is a solace. Within a couple of minutes I will be concluding. But consequence was, if our courts are so competent, our judges are so learned judges, why it took long 15 years from 2005 to 11th August 2020? This is the long 15-year span. What was wrong in the drafting? And wrong in the drafting was as to the words on and from. These two words were misleading, and they have misled the judges of the High Court and Supreme Court. They were carried by their different interpretation because of only these two words, on and from. So they are made co-partners from what date? 9/9/2005, on and from the commencement of this act. So on and from this date. So whether on and from, they are to be read together or differently was the question. So she is made a co-partner. By this amendment, what has been done? She is made a co-partner. And secondly, what has been done? Property is given to her. She is made a co-partner from what date? And that was the controversy before the courts. In this amendment, it is said that she is made a co-partner by birth. So say for instance, a daughter is born, say for instance, in the year 1950. And we are discussing her rights in the year 2005. She is made co-partner when? In 2005 or by her death? By her birth. She is made a co-partner by her birth. Right is given when? Today. Try to understand. She was made a co-partner on 1950 or her birth, and right is given on 9/9/2005. This was the controversy in respect of this entire law. This took, to settle this controversy, 15 long years. But today, law is settled. Everything was very correctly done, but was a case before Delhi High Court. And the case was, I will conclude now. The case was Sujata Sharma versus Manu Gupta. Very interesting case. Justice Najmi Waziri of Delhi High Court, he decided this case. When Justice Najmi Waziri of Delhi High Court, he decided this case of Sujata Sharma versus Manu. Interesting facts I will tell you. How law has been stretched. What are the far-reaching consequences the lawmakers did not contemplate? And is the case of Delhi High Court decision of Justice Najmi Waziri in this case. When case came before Delhi High Court, facts were very simple. Facts were, as we have got farmhouses and lands in around Pune, as we see. Likewise in Delhi and around Delhi, there are big farmhouses. And the values of the farmhouses are 100 crore and multiple thereof. There was a family called as Gupta. In this Gupta family, there was a father, there was a son, and there were two sisters. So 4 members in short. And there are huge properties. Of these 4 members of the family, elder daughter Sujata was married during the lifetime of father, and she was living in that Sharma family. Daughter from Gupta family was given in Sharma family, and she was there in the Sharma family. Father died. After marriage of daughter, father died. After father's death, how many members? 1 son, 1 unmarried daughter, and 1 married daughter. So this married daughter and brother, amongst them there was a controversy. And when there was a controversy, she filed a suit in Delhi High Court, original side. As Bombay High Court has original side, Delhi High Court has original side. In original side, there was a first suit instituted in Delhi High Court by this sister Sujata Sharma against her brother Manu Gupta. And when suit was instituted for partition, she said that I am like a son. I have got equal share with you. Then this brother realized, yes, he must give equal share to sister. He came with folded hands in the court and said, sister, you can take your half share. You can take your equal share with me. Because daughter is treated as a son. So take equal share. But she said, as you know, most of you, and especially from rural areas, they know, clothes in the blood are bloodiest. And this clothes in the blood are bloodiest. Therefore, this daughter had a very bitter relations with brother. Bitterness exhibited in the court. When son said, or brother said, you can take your equal share, she said, yes, I will take equal share. This 2005 law has given me equal share, but I am not happy with that only. I want something more. Court asked her, what do you want something more? She said, look, as per the traditional Hindu law, senior-most co-partner becomes karta of the co-partnery. She said, I am the eldest sister. You are the youngest brother. This is the middle sister. Today there are 3 members. And of the 3 members, I am the senior most. I want to become karta of the co-partner. In India, all courts in India, for the first time, very interesting issue arose before Delhi High Court, before Justice Nazmi Waziri to decide whether a married daughter, Sujata Sharma, living in Sharma family, can become karta in Gupta family or not. Where she is married, Sharma family. Where she resides every day and works, in Sharma family. And she wants to become karta of brother's family. Issue was whether she can become karta in brother's family or not after marriage. If it is unmarried, we can understand. Whether married daughter in husband's house can become karta in brother's house or not. Was the controversial question for the first time in India arose. And then when that issue arose, the consequence was, the judge said, look, I am bound by the principles of law. What law says? Section 6, 1A says that she is made a co-partner by birth. So if she is made a co-partner means senior most co-partner can become karta of the co-partner. So ultimately has been held that such a married daughter in husband's house can be karta in brother's house. Law has been stretched far away. But as I have said, in Delhi, it's very simple to go to the Supreme Court. This case has also traveled that square and now is pending for final decision in the Supreme Court of India, whether law can be stretched to that extent or not, is the question. Friends, as I have understood and discussed these various issues, at one session, at one place I was just delivering a session, a very young advocate asked me, sir, you have explained these various things, but I have not understood that way the effect of this law. I will conclude within a couple of minutes. So he said that I am not in a position to understand the effect of this law. What has went wrong? I said in one language in Marathi to him, those can be benefited who understand Marathi. He said, sir, what is the defect? I said, look, defect is, in Marathi, Aag lagli Rameshwari, Bamba patwala Someshwari. What it means? The fire broke at where? Someshwar. The fire brigade is sent where? Rameshwar. So what was the defect? Where her rights were denied? In husband's house. In husband's house she was not given any right. Rights were denied to her. Dowry was claimed. And right is given where? In brother's house. Actually, protection was required where? In husband's house. There no right is given till today. And right is conferred in brother's house. So, this is the consequence, friends. Because of this, you will find today there is 70% litigation. 70% litigation in the courts based on this section. Try to understand this. If you understand this, then you will prosper in your lawyering and advocacy. Because most of the litigation is based on this. Because this is based on the consequence that you'll find now brothers and sisters are not meeting for Bhau Bij or Raksha Bandhan. They are meeting in the courts in lawyers' offices today. That is the consequence in respect of this. Friends, I will conclude. At one step, in a particular lecture, we are sitting there and discussing like you people, but it was advocates' discussion. As a consequence thereof, a young boy arose and he said, "Sir, you have told everything, we have understood." That was a compliment to me. But he said, "Sir, I am not understanding what is this prospective, retrospective, and retroactive. I am not understanding it properly." And at that meeting, there were very senior lawyers also with me. Advocate General of Bombay High Court, he was also with me. We all three discussed how to make this boy understand. He said that, "I have understood everything." So it was compliment to us. We are good teachers. But he said that, "I have not understood this." So we have to explain him what is retrospective, prospective, and retroactive. And then I tried, and all of us, we tried to explain to him, but he was not in a position to understand. Rather, he was not understanding, or he was just taking us for a ride. Then, as this was done, with the permission of other two, I have explained to him, what cannot be understood by language can be understood by actions. It is well said. So, I tried to make him understand with the help of the action. What is prospective? What is retrospective? And what is retroactive? That action I will make for you, and then I will conclude. Friends, what is prospective means, say for instance, I am present here, and this is 992005 range. This is law came into force, and we go forward means prospective from 992005 forward prospective. Again, I am on the line of 992005, and I go backward means retrospective. He said, "Yes, sir, I understood prospective. I understood retrospective also." He said, "Sir, I have not understood retroactive." I said to him then, "Say, friend, this is 992005. And when I look backward and go forward, then this is retroactive. This is the consequence in respect of retrospective, prospective, and retroactive." Friends, thank you very much. Friends, with this, I conclude. Really, this is only part of the discussion. Women empowerment, the book which I have given to you, there are various segments. There are 4 segments in my book which will be distributed with the permission of the principal. But what today we have discussed is only 1/4 of that note will be circulated to you. Friends, because of the time constraint, I have to take your leave. For the giving this opportunity to address you, to be associated with you, I am very much thankful to Principal of this Law College, Mrs. Shinde, and my esteemed colleague and friend, Ananta Randive, for giving me this opportunity to share my views with you. Thank you very much.
Hello. Thank you so much, sir, for sharing such valuable information with us. We all really were enlightened by your words. Now, I request Advocate Anant Randive, sir, to kindly come forward and give vote of thanks.
Good morning, all. Say good morning. Okay, that shows that you are here physically and mentally. I don't understand the clappings are for to finish the program or to invite just because I came here. Of course, now my lecture's time is not there, so I will not speak 45 minutes again. I respect your, yes, you are correct. And I don't know why the organizers have said me to say the thanks, because generally it is not expected from teacher like me. But of course, since they have asked me for vote of thanks, it is my privilege to organize these wonderful programs to all these students. And I'm very happy that being a part of this program, I contributed some sort of for this organizing this program. At the beginning, I must thank from the D.Y.PATIL Law College and Randive Randive Associates and from the entire college to my guru, Dr. SUDHAKAR Award sir, for accepting our invitation on such a small span. Sir, I'm sorry that first I inform you 16, then I'll again 14, but you say it's a college program. I will be here definitely, whether it is 14 or 16. Let us have a good clap of this sir for accepting this. Sir, this is our second generation that which is associated with the sir. My uncle was there, then me, my brothers, then there my brothers also there. We are so fortunate that we have attended lectures of our sirs in his own classes. And we are having experience of all this in detail knowledge. Sir, I can say from standing here that being a teacher of last 18 years, only 20% I can deliver what you have delivered today. That is what the confession. I hope you will agree with me. In detail knowledge that we started from Vedas to the Supreme Court, and that to the recent case laws of the Delhi High Court, where the controversial issue of the kartas of the women is there. Sir, this is what what you can say, the encyclopedia for we people, sir. It gives very in-detail knowledge. And sir, I will not say thank you for coming here, but I will say, sir, we are again and again going to invite you on these occasions to deliver the lecture, sir. And it will not be in formality that I say thank you for our principal ma'am, because she being a torchbearer of every time. Whenever I say, ma'am, we have to organize this, she says, yes, you organize this. Without any hesitations, without any barricades, she says, yes, we organize this. She is the main pillar for organizing all these programs. I must say thanks from bottom of heart from all these students, not for my organization, but all these students that are organizing such a wonderful programs. Let us clap for our principal ma'am. Then, last but not least, the organizing committee who has worked there for last more than 10 days. Madhavi ma'am is there. All the colleagues for organizing entire, like from selecting this banner and the momentum, all these things. And you students. Generally, I know that I can read this, because being a professor, I can read. After 45 minutes, you started doing all these activities. But today, you prove that you are a good student, and I'm very proud that but at the same note, that doesn't mean that you will take disadvantage from tomorrow. I thank all the students, the organizing committee, all the staff of D.Y.PATIL Law College, and those lawyers who are attending today's sessions. Thank you very much. And I am looking forward for organizing again and again such kind of lecture series in this in association with D.Y.PATIL Law College. Lastly, I will thank the D.Y.PATIL Law College for giving an opportunity for the organizing such kind of programs here. Thank you very much. One more request with the permission of the sir, that as sir said that there is a copy available of ready-made material of again written by the sir. Might be it's 100, 200 copies are there. If someone is not getting the copy, definitely we'll provide the copy. Okay, one by one, they will distribute the copies of the books, and if someone not getting the copy, we'll get the copies of the book also. Thank you for organizing.
Thank you so much, sir. Okay. Here we conclude this session. Thank you so much, Principal Ma'am. Thank you so much, Honorable Sir, and students for attending. We have arranged snacks for all the students outside, so kindly come and collect it. Thank you.
Please be seated till the guests are here. Please be seated. Irish, I need few volunteers to distribute the study material.